Sorry, you want you good? Right.
Good morning, everyone.
Morning.
This is the Court of Appeal.
We've lost you, Mr. Coelho.
Can you hear me now?
Yes,
Okay.
this is the Court of Appeal. Did you say something after that?
Yes, this is the Court of Appeal sitting in Bermuda for Criminal Appeal number 3 of 2020, the Queen against Chez Rogers, which is before my Lord Acting President, Mr. Sir Morris K., Mr. Justice Jeffrey Bell, QC, and Dame Elizabeth Gloucester. As a matter of housekeeping, all electronic devices and objects capable of making noises and disrupting these proceedings, such as mobile phones, landline telephones, alarm clocks, children's toys, etc., should be removed from your immediate surroundings and/or disengaged. These proceedings are being live streamed via the Court of Appeal's webpage, that is to say www.gov.bm/court-appeal for the benefit of the members of the public. Thirdly, these proceedings are being recorded and copies of the audio can be acquired in the usual way. The video recording of these proceedings will not be released by the court unless an application is made and an order given by a single judge or the Court of Appeal. Unauthorized reproduction of any kind of these proceedings is prohibited.
Thank you.
Clarke is appearing for the Queen applicant, and Mr. Charles Richardson is appearing on behalf of the respondent, Mr. Rogers. Ms. Clarke.
Thank you. Good morning, Ms. Clarke. Mr. Richardson.
Good morning. Good morning.
Morning.
Yes, Ms. Clarke.
Morning, my lord. If I can start, and my lady, if I can start by just correcting Mr. Coelho, I appear on behalf of the appellant. Leave was granted for this appeal on the 7th of October 2020 by the single judge of the Court of Appeal, my Lord Justice Bell.
Yes.
Yes.
Just another bit of housekeeping, my lords and my lady. You should have the record of appeal. Mine looks like that. Should also be a transcript of the sentencing proceedings. Written submissions from myself and my learned friend, Mr. Richardson, as well as a joint authorities bundle. I'm grateful. So, my lord, my lady, my learned friend and I are not too far apart on the law with regards to certain tests in this appeal, but the appeal by the Crown is on 2 grounds. The first, that the sentence that was issued by the learned sentencing judge in respect of an offense of unlawful carnal knowledge of a girl under the age of 14 was manifestly inadequate. The second ground is that the sentence for the offense of luring was also manifestly inadequate. So if it pleases the court, I'd like to pick up at paragraph 4 of my written submissions, just to reference the summary of evidence briefly. So as I mentioned in my written submissions, my lord, in short, the case for the Crown was that the respondent was 19 years old and the victim was 13 years old at the time of the offenses. I can say specifically she was 13 years old in 3 months or 4 months during the course of these offenses. So she was at least 8 months shy of her 14th birthday. The defendant had sent messages that were sexual in nature via social media to the victim, and the victim and the defendant had vaginal and oral sex on 2 occasions between August and September of 2019. And Mr. Pillar, should I wait for the prisoner?
Good morning.
Yes.
Yes, I hadn't appreciated that the prisoner had not signed in.
Oh, right.
CEO Balboa, is Mr. Rogers nearby?
Yes, he's ready.
Okay, you can bring him in.
Okay, thank you.
Thank you.
And I no longer see Mr. Richardson on the top of the screen.
No, I do.
I'm here, my lord.
If you go to gallery view, you will see him.
Right. I'll do it.
Morning. Morning.
Mr. Richardson, Mr. Rogers will have missed 2 or 3 sentences. Do you want them repeating, or can we just carry on?
Mr. Rogers, do you want us to repeat what was said? You haven't missed anything significant. I said, do you want us to repeat what has already happened in your absence? I can assure you, you haven't missed anything significant.
I'm out of me.
Okay, we can go ahead then, my lord.
Thank you very much.
Thank you, my lord. Thank you, Mr. Richardson, for the concession. So the issue, my lords and my lady, before the court is whether or not the sentence that was imposed for the unlawful carnal knowledge, which was only 2 years imprisonment in our submission, was manifestly inadequate or wrong in principle, and that the sentence imposed for the luring, which was only 18 months imprisonment and 12 months imprisonment for luring.
Well, can I interrupt you, please? There is some interference, some technical interference. May I mention that if everybody mutes themselves other than the speaker, that should disappear. I mean, I've just got a bit of an echo, slight echo when you're presenting.
Is that better, my lady?
I've still got it, but it doesn't matter. Continue.
I'm grateful. As I mentioned in the beginning of the submissions, my learned friend, Mr. Richardson, and I agree that the term manifestly inadequate can be defined as obviously inadequate, obvious to the appellate tribunal that the sentence is much too low and fails to reflect the feelings of civilized society to the crime in question. It's also defined as the judge having acted on a wrong principle or has clearly overlooked or undervalued or overestimated or misunderstood some salient feature of the evidence. So as I mentioned, there's no, that's from Planton Robinson, which is at our tab 1, but there's no dispute between my learned friend and myself as to that. I would remind the court that the maximum sentence for this offense was 25 years for the unlawful carnal knowledge, and it is 10 years for the luring. The crux of the Crown's complaint is that by imposing the sentence of 18 months imprisonment, the learned sentencing judge failed to properly consider the sentencing ranges that were set by this court in the cases of Brangman and Rogers. So I would pause at this point, my lords and my lady, to say that we accept that particularly in sexual cases and those of unlawful carnal knowledge, it's very difficult to find a case that is on all fours factually with a case that is being sentenced by the courts. The respondent, in first instance at the sentencing and again at the leave application, his position has been that the section 180, which is what this offense is under, cases are disparate because they're considered to be more serious than the case at bar. We submit that we're not relying on those two cases to be of, as I mentioned, similar facts, but to assist in determining what the starting should be for offenses contrary to section 180. So my lord, if I can take you, my lords and my lady, if I can take you to tab 3 first of the joint bundle. And my lady, unfortunately, I can't see if you've actually gotten to the tab with the way the camera is written, so if you can just let me know when it's good to move
Don't
on.
worry, I'm there or I'm on the electronic. I've got it all here. So don't worry about where I am.
So the first case, as I mentioned, is at tab 3. It's the case of Colonel Brangman. Case from these courts from 2019. So it's the judgment of then President Justice Clarke. And if you look at paragraph 2, it was an application for leave to appeal by the defendant. He himself had been convicted by a unanimous decision of the jury in respect of 2 counts of sexual exploitation of a young person by a person in a position of trust, and 1 count of unlawful carnal knowledge of a girl under the age of 14. Initially, the sentences that were imposed, particularly for the unlawful carnal knowledge on count 3, was 12 years imprisonment. Now, I accept that this case is far more serious than the one that we are dealing with this morning, and he also went to trial. But by way of background at paragraph 5, in that case, the case presented by the Crown, which the jury must have accepted, was this. The victim, AB, was the applicant's stepdaughter, he being married to her mother. During the summers of 1998 and 1999, when AB was 10 to 11 years old and alone at her home, the applicant would come there on his lunch hour. During these visits, he would perform oral sex on her, the subject of count 1, and get her to perform oral sex on him, the subject of count 2. AB said that this would occur at least twice a week. On one occasion during the summer of 1998, the applicant had full sexual intercourse with the victim. That was the subject of count 3. The victim told the applicant that she did not want him to have sex with her as it would hurt. The applicant continued to have sex with her nonetheless, even though she told him to stop and that he was hurting her. AB said that after a few minutes, the applicant did stop. So if I can move to paragraph 10, which is on the 3rd page, the court said, it is apparent that the case had a number of seriously aggravating features. And I pause to say, I'm not saying that the case we are arguing this morning has these features. The first was at the age of the child, she was only 10 years old at the beginning. The second is the fact that the applicant was in a position of trust. The victim was his stepdaughter. And the third is that these crimes took place in her home, which should have been for the victim a place of safety. The fourth is the difference in age between the victim and the applicant, over 20 years. The fifth is that the unlawful carnal knowledge occurred despite the victim's resistance. The effect of all this was that the victim bore the burden of what she had suffered for over a decade before she revealed it to anyone. And it was only after counseling that she felt it possible to reveal it to the police. So, my Lord,
Ms. Clarke, just interrupting there for a question. I mean, you accept that each one of those is a very serious aggravating feature which is not present in the case before us.
I do, my Lord, and I'm indicating that in this case, the applicant received a sentence of 12 years, which was ended up being upheld by these courts. Perhaps I should have said at the start, what we say the appropriate starting point for our case this morning was 6 years, and the appropriate sentence was one between 3 and 4 years. So I'm not trying to equate this case of Bregman or the case of Rogers, which I'm about to go through as well.
Well, is there a case that you can point us to that supports your contention that the starting point is 6 years on facts similar to the facts of the case before us?
No, my lords, what I'm asking the court to consider is looking at the only 2 cases we have in the Court of Appeal for this offense, which I accept are more serious, and then to come down from the aggravating circumstances in those 2 cases to figure out what the starting point should be if those aggravating circumstances are not present. Unfortunately, I don't have a case before the Court of Appeal for this offense on these types of less aggravating features.
Right.
And this is why the Crown has made this appeal. We don't have, and I think it would be difficult to do, any guideline case that talks about a starting point that isn't factual based or aggravating features heavy. So, my lord, if I can, and my lady, if I can take you to paragraph 24 of that same Parnell Bregman case.
Rogers.
Yes, so this is where the court was going through the case of Rogers, which is the case that we do actually have at our tab 4.
Yes.
The court said in Cleveland Rogers, the respondent had pleaded guilty to one offense of unlawful carnal knowledge, contrary to section 181 of the Criminal Code. Now that's actually incorrect because, as you can see, the victim was not yet 14, so it must have been 180 brackets 1 as opposed to section 181. All of the offenses occurred over the course of one night. This court increased the sentence of 5 years imprisonment for the offense of unlawful carnal knowledge imposed at first instance to one of 7.5 years imprisonment. That sentence was imposed following a plea of guilty, and the victim was a few days short of her 14th birthday. The respondent was 46 years. He had a relationship with the victim's mother. In that case, this court was referred to a number of authorities, but was not persuaded that any of them were of great assistance with regard to the appropriate sentence. And I'm going to pause and say to my Lord Justice Bell, it's the same situation here. Whatever cases we put forth, whether it be the cases that I have relied upon, and I'm going to submit the cases my learned friend relies upon, that they're of no great assistance with regard to the appropriate sentence because we've not had a sort of global benchmark sentencing judgment out of these courts. So at paragraph 25, the Court of Appeal identified several aggravating circumstances, namely A, that the offenses occurred at night whilst the victim was asleep in her own bed in her house, B, the age disparity between 14 years and 46 years, C, the breach of trust given that the respondent was in the house due to his relationship with the victim's mother, and D, the respondent's return to the victim's bed after being disturbed by the mother, after which he committed the offense of rape. The respondent had a number of previous convictions, mostly in the last century, and none of a sexual nature. The only mitigation was the late pleas of guilty, for which the judge and the Court of Appeal were content to give a 15% discount. And the court thought that in the particular circumstance of this case, and we emphasize those words, the total sentence should be 7.5 years. So, my lords, we've got the case of Parnell Brangman, which we say is at the more serious end, where 12 years is given after a trial. We've got a more serious case where a plea is entered and it's 7.5 years on what I say I accept is a more serious case.
Ms. Clarke, in Rogers,
Yes.
Sir Scott Baker, President, equated the circumstances of that case, and I'm sure you're going to come to it in the bundle, but he said that the offence could in reality only be described as the rape of a 13-year-old.
Yes.
Child, I should have added, saying not only was she in no position by virtue of her age to consent, but as a matter of fact, plainly she did not consent.
Yes.
I mean, completely different level of seriousness.
Yes, my lord, and I accept so. I'm putting these two as the high levels.
Yeah.
Those tend to be the cases that these courts deal with. We don't have any guidance what to do for this offense at the low level. What my learned friend is seeking to persuade the court is that we should look at the offense of unlawful carnal knowledge of a 14 to a 16-year-old girl and compare those two be more relevant factually. But the Crown's position is that we cannot look at a different offense to figure out what the appropriate sentence should be for this offense, simply because those facts might marry up a little closer.
Well, in practical terms, if one looks at Mr. Richardson's cases, which are section
181, subsection
181 cases,
yes,
they have none of the aggravating features that appear in Brangman and Rogers, and the difference in terms of the section under which the defendant was charged arise from what is in some cases a relatively minor difference in age of the victim.
Well, yes, my lord, but there is a case that I did provide of Gribby out of the UK, and a case that is the Attorney General's reference referred to as Brown, that reminds these courts that we should not be looking to say what would have happened had the victim been a few months older. I will go quickly to tab 4, which is the case of Rogers. And my lord was, of course, quite correct that President Baker at the time did indicate at paragraph 7 of tab 4
Yes.
that the offense of unlawful carnal knowledge can in reality only be described as the rape of a 13-year-old child. Not only was she in a position by virtue of her age to consent, as a matter of fact, plainly, in no position, sorry, by virtue of her age to consent, but as a matter of fact, plainly, she did not consent. So that is the paragraph that my lord was referring me to.
Yes.
We look, my lord, over at paragraph 12. It's on page 4. The court says, Ms. King submitted that as far as count 1 was concerned, the appropriate range of sentence, that is for unlawful carnal knowledge, was 7 to 9 years. In the circumstance of the present case, and counts 2 and 3 and 4, 5 to 7 years. And the court said, we think the correct approach is to start by looking at the totality of what happened on the night in question. And so that, my lord, that is what I'm saying is the only guidance that we've got in how to deal with these types of sentences. If I can go to the 3 cases, the local cases that my learned friend has referred to, the first appears at tab 5.
I think what you're saying is that we haven't got a case that's on all fours with this.
No.
We've got far more serious cases which attract far heavier sentences. and we've got less serious cases that attract lighter sentences.
Yes, my lord.
This case should be somewhere in between.
That's exactly what my
Whether
position.
it should be nearer one group or the other.
Yes.
Plainly, the judge thought that it came much closer to Mr. Richardson's cases than to your cases.
Yes, my lord, and I'm not even suggesting that I was that far off. My original submission was 3 to 4 years imprisonment. So even my submission and recommendation was closer,
yes,
to referred to than it was to the guideline cases by this court. The difficulty I have, my lord, though, is that it's our submission that the sentencing judge was in fact too concerned with the cases imposed by my learned friend and equated them with this offense, which even though I hear my Lord Justice Bell indicating it's close, but for a few months, as I indicated, when I get to the cases of Gribby and Brown, that is a dangerous path to take in my humble submission by any sentencing judge. So if I can just first, at tab 5 is the case of Erin O'Connor, which is one of the cases that was before the sentencing judge and also before my Lord Justice Bell on the leave application. It's at tab 5. This is a matter from the Court of Appeal. Again, it was then President Justice Baker, and it was in relation to a 2015 offense, but it was Erin O'Connor, the appellant, was convicted on his own confession of unlawful carnal knowledge, contrary to section 181(1) of the Criminal Code Act. The complainant was 14 years and 10 months at the time of the offense. The appellant was 20 years and 4 months. So I will say just on that fact alone, yes, that is closer in facts, but the sheer fact that the complainant was over 14 does bring it to a lesser offense. And I've heard my lord indicate that it's only a difference of 5 years, but that is a massive difference when it comes to what a maximum sentence could be. And it is a massive difference to indicate how Parliament saw fit to give a higher sentence for that offense. Now, there is no real discussion of sentence in respect of Erin O'Connor by either side. There was no appeal by either side. The issue in Erin O'Connor is whether or not the appellant should have been charged with sexual assault.
It's an appeal against conviction.
It's only a conviction, and it's no comment at all on whether the sentence was appropriate. So that's the first reason why I say, unfortunately, Erin O'Connor doesn't help us with what the appropriate sentence should be for Mr. Rogers.
But it's not authority for anything that we're concerned with now, is it?
No, it's not, but I'm grateful, my lord. If I can go then to tab 6, Malik Zul. So again, this is a case by my Lord Justice Chez from 2015. This was an appeal against sentence. He pled guilty to 2 counts of unlawful carnal knowledge, contrary to section 181(1) of the Criminal Code. The factual background is stated shortly at paragraph 3 on page, mine is not paginated, but on the second page of paragraph 3, where the court said the appellant was 17 at the time of the offenses. He'd only recently reached his 17th birthday, and the complainant was 14, but she was very nearly 15. So what I point out in respect of this case, my lords, is that Malik Zul, having only been 17 at the time of the offenses, would have been subject to a completely different sentencing regime under the Young Offenders Act. And I haven't put it in, but I'm sure the court will remember that the Young Offenders Act requires that a defendant not be imprisoned without reason. So it's a completely different sentencing regime that I would indicate is of no use to the court in respect of this case this morning.
And the sentence that Mr. Zewell ended up with is less than half than the sentence that was imposed in the present case.
That is correct. I will remind the court is if you look at, again, paragraph 14, the court said on the 3rd line, we have had regard to the authorities referred to by the attorneys on both sides. Again, we do not find them to be on all fours with the present case. Very often they are concerned with the men of older years and or a girl younger than the complainant. And very often they are concerned people, particularly defendants with a worse criminal history than this appellant who had no previous convictions. But there is, if you look, my lords, at paragraphs 18 through a good portion of that judgment, the issue of that appellant's mental state was quite live.
Sorry, Ms. Clarke, I missed the reference there. After paragraph 14, you took us to?
Paragraph 18.
18, thank you.
Where the court spends quite a few paragraphs discussing the appellant's mental state.
Yes.
There's also a live issue in that appeal for sentence. And if I can take you over to paragraph 21, the court said, finally, we come to the point which seems to us the most important one on this appeal, that is the age of the appellant. Although he is now 18, at the time of the offenses, he was just past his 17th birthday. This means this is not a case of a much older man taking advantage of a 14-year-old girl. He was more than 2 years older than her, and he was still of an age where his youth was an important factor when considering his sentence. On the other hand, this is not a case of teenagers of approximately equal age and the experience simply exploring sex for the first time on an equal basis. Not only is he 2 years older, he was far more experienced in sexual matters than she was a virgin. So, my lords, I simply submit that unfortunately, in my humble submission, Malik Zul can't be of any assistance to us in figuring out what the appropriate sentence should be for Mr. Rogers either. And the last case that was local case that was put forth by my learned friend is at tab 7, which was the Court of Appeal case of Sean Gordon Smith from 1999. So it says that it was an application by the Crown for a leave of appeal of 18 months imprisonment imposed on Sean Gordon Smith for the offense of having unlawful carnal knowledge of a girl above the age of 14 and under the age of 16. And notwithstanding it's an appeal against the sentence, the issue that is being dealt with by the court in this case is not whether it's an appropriate sentence for UCK. The judgment focused on whether the more serious offense of sexual assault should have been considered when the sentencing was done. So unfortunately, even though the court does talk about the age disparity, it doesn't get into much in respect of whether or not the sentence was appropriate for UCK. They simply indicated on the last page, which is page 4 at the top. Unfortunately, these are not paragraphed, but the last page of the judgment is a handwritten 161, the typewritten 4.
Yeah.
But the third line down, it says, counsel for the applicant is seeking to introduce facts of another more serious offense and is inviting the court to impose a sentence of imprisonment based on these facts. So that is the issue that was being dealt with by Sean Smith. They didn't comment on whether 18 was the right number, 18 was too low, too high, just that the Crown should not have been trying to refer to more serious facts for an offense they left on the file. So those are the 3 authorities that were before the sentencing judge at the time. And we submit that these are of no assistance to the court. It's for a different offense with a lesser penalty. They historically receive lesser sentences. So we would indicate that unfortunately, these do not assist the court any further. We do, however, submit that it is of no assistance to this court to, and I'm at my own paragraph 18 of my written submissions. It's of no assistance to this court to emphasize the victim was a few months shy of her 14th birthday. As I mentioned, she's at least 8 months shy of her 14th birthday. And therefore the respondent, but for those few months, could have been charged with a lesser offense. It is the very fact that the legislature saw fit to designate a separate offense for these facts that can only be tried in indictment that indicates the level of seriousness that should apply to this offense. And my lords, that is a paraphrase from the case of Gribby, which is at our tab 8. So I will say initially, my lords, that this is a UK case. And even though most jurisdictions have a limit on which offense is the one that is considered to be a felony or an indictable only matter, in the UK, it's the age of 13, not 14. So I rely upon the case for the legal premise being put forth, but obviously I can't rely upon the age that was in respect. So the offense is under Section 5 of the Sexual Offences Act 2003, and it is still referred to as rape of a child under the age of 13. In the case of Gribby, the appellant was 18 years of age at the time of the offenses, I believe. So if we look at paragraph 12 of Gribby, which is on the second page.
I'm just trying to see, Ms. Clarke, where the charge is dealt with in
The charge is at paragraph 2.
Thank you.
Where it confirms he pleaded guilty to 2 counts of rape of a child under the age of 13, contrary to Section 5 of the Sexual Offences Act 2003. Paragraph 12, if I can, my lords, my lady.
Yes.
The third line down, it says, by this time, the offender had attained the age of 18 years. The offender pleaded guilty to counts 1 and 4, being 2 counts of rape of a child under the age of 13, on the footing that the sex was not forced, that is to say, on the footing that it was consensual. Skipping to paragraph 13, the offender has no previous convictions, cautions, reprimands, or warnings of any kind recorded against him. And if I can go across to paragraph 25. The court said, we do acknowledge that this was a difficult case. However, that said, we do not, with all respect to the judge, think that the sentence can be maintained. The very designation of this kind of offending, rape of a child under the age of 13, indicates the seriousness with which Parliament intended the offending of this kind to be viewed. It is an offense which is statutorily different from the offense of sexual activity with a child. In such circumstances, the mere fact, if it be a fact in any given case, that the underage victim has consented and that no force or coercion of any kind is used or needed cannot of itself give rise to some exceptional factor justifying a wholesale departure from the guideline. The inability of a child under the age of 13 to consent in law to penile penetration is inherent in the offense. Of course, if there is force or violence or threat or coercion that renders what is in itself already a serious offense, an even more serious offense, as categorization in the definitive guidelines illustrates. But the converse is not true, in the sense that consent by the underage victim, even if of itself is of some relevance, does not cause the offense to be considered as in some way exceptional. The underlying statutory rationale, it must be remembered, and as the judge here himself rightly indicated, it is that children under the age of 13 require protection for their own benefit. They need, as it were, to be protected from themselves. The emotional immaturity precludes, as has frequently decided and as Parliament has confirmed, the notion of any informed consent. That, in fact, may be particularly so in those cases, not this case we stress, where the child under the age of 13 is seemingly an enthusiastic participant. And they reference the case of Brown, which I will get to eventually.
Well, the judge in our case was very mindful of all that because she said so when she was rejecting Mr. Richardson's more outlandish submissions.
Yes, my lord. My complaint with the judge is not even the rationale and how she came to sentence. It's simply she started too low. If I can also read paragraph 29 of the same case of Gribby. It says, it may be that B was very nearly due to reach her 13th birthday. But as the judge pointed out, the differentiation in age here for these 2 young people was a gulf, even if the offender himself had not reached the age of 18 at the time. Moreover, the lack of frankness of the offender, or actually the rest of it's about his interview, but I read the first 3 lines to point out the differentiations of age, even its gulf, even though the offender hadn't reached the age of 18. Our offender was 19 at the time. And as I mentioned, the victim was 13 and 4 months. And if I can also go to the case of Brown, it's the Attorney General's reference at our tab 9. It is a case from the UK Court of Appeal. Again, it's an offense, as I mentioned, under Section 5 of the UK Sexual Offences Act, which is referred to as the rape of a child under the age of 13. Paragraph 2 confirms the offender is a young man called Jack Brown. He's 20 years old, having been born on the 1st of June, 1995. On the 24th of September, 2015, at a preliminary hearing in the Bristol Crown Court, he pleaded guilty to a single count of rape of a child under the age of 13. Skipping to 3, the background position was this: the victim was a girl who was aged 12 at the time of the offense, having been born on the 19th of September, 2002. The offender was the partner's brother, and he was 19, as I mentioned. In paragraph 3, it says they had consensual sex on 1 occasion. The offender was wearing a condom, but it split, and in the result, the victim became pregnant. So that is the factual background to this particular case. If we can go to paragraph 21. The court said the following aggravating and mitigating factors can be identified as present in this particular case. In terms of aggravating factors, in essence, the one particular aggravating factor over and above those inherent in the correct categorization of his offending was the fact that the offender had told the victim not to tell anyone of their relationship. It is clear the offender, of course, knew that she was under the age of 13 and that what he had been doing was wrong. On the other hand, there was a great deal of mitigation present. First, the offender had no previous convictions of any kind. Second, there was clear and genuine remorse. Third, he was himself relatively young, being 19 at the time. Fourth, and importantly, his various learning and other disabilities and the evidence of his immaturity. And finally, there was his guilty plea for which full credit fell to be accorded. If we go across to paragraph 25, the court said, we should add that during the course of the address to the recorder, his attention was drawn to the guideline relating to the offending under Section 9 of the Sexual Offenses Act 2003. And I can pause at this point to say my understanding of Section 9 would be the equivalence of our it's a mix of the two offenses we have, the UCK for the higher age, as well as it looks like sexual exploitation is also.
Sorry, Ms. Clarke, could you just take that again a little more slowly?
I apologize. So
Section 9 is the equivalent of what?
Of our UCK 14 to 16, but theirs is 13 to 18. But it also seems to also encompass portions of our sexual exploitation offense. So it has touching that isn't necessarily penile penetration involved as well.
Right.
So the point sought to be made was that the victim here was but a few months short of her 13th birthday. And therefore it was appropriate for the court to consider what the outcome might have been had only the charge been by reference to an offense under Section 9 on the footing that the offender had been, which I guess it should be the victim had been 13. Mr. Jarvis for the Attorney General submits that the entire approach of the recorder involved a misapprehension of the proper rationale underpinning the provision of Section 5 and also involved an unwarranted application, or as he would say, misapplication of the guideline. I pause to say that is the complaint that I make of the sentencing judge, that she has a misapprehension of the proper rationale underpinning the offense of Section 180 of the Criminal Code. The court went on to say he submitted that the recorder was quite wrong to regard this as an exceptional case or one that departed from any norm. He submitted that so radical a departure from the recommendations contained in the guideline by reference to Section 5 offending, which connoted a starting point of 10 years, simply could not be justified. Mr. Comer, on the other hand, appearing for the offender, said that the recorder was entitled to regard this as an exceptional case. Mr. Comer emphasized that the victim was indeed only a few months short of 13 and seemingly relatively mature, whereas the offender was actually immature and had all his problems. Furthermore, Mr. Comer placed much emphasis on the fact that the victim had wanted this relationship and had willingly participated in the sexual intercourse that had occurred. We can agree with Mr. Comer that cases of this particular kind are almost invariably difficult and sensitive, but we are in no doubt that the particular sentence cannot be upheld. We think that it was quite wrong we think that the recorder was quite wrong to assess that this was an exceptional case, such that he could impose a non-custodial sentence. The sentence was, in short, unduly lenient. First, we think it can be potentially misleading to have had overmuch regard what the position might have been had only the victim been 13. The short point is that she was not 13. And in this case, we say she's not 14. She was 12 and a half. She was a young child. Further, the whole point of this particular provision is to protect young children from themselves, to emphasize, as the recorder did, that here there was no force, there was no manipulation, here there was no coercion, misses that point. The consent given is consent in italics and quotes. To be put in italics, a child aged 12 cannot lawfully consent. Of course, it is relevant that no force or coercion as such was used, but the underlying point remains that children such as this victim need to be protected from themselves. If I can go over to paragraph 33 of the same case. The court says we acknowledge the very powerful mitigation available to this particular offender, which we have already recited. And of course, we bear in mind the point that he did not, in fact, use force or coercion. In our view, in particular, given the circumstances relating to the personal situation of this offender, the recorder would have been well justified in the fact that going below the bottom of the range indicated in the guideline. And I pause to say, I take no complaint or find no fault in Justice Simmons going below the guideline that has been put in the two more serious cases. We just say she went too far. We consider, having regard to all mitigation available, that the recorder could probably have taken a starting point, given credit for the plea of some 6 years custody. And that's where we say she should have started in this case as well. Giving then full credit for the plea, that would bring the sentence down to a sentence in the order of 4 years custody. And as I mentioned, I even submitted that 3 years might have been sufficient. So, my lord, that is the authority of the Attorney General's reference referred to as Brown. I'm at paragraph 21 of my written submissions now.
Yep.
That the sentence imposed by the learned sentencing judge was disproportionate to the gravity of the acts of the respondent, and that the respondent's acts were highly reprehensible and sufficiently serious, and he was sufficiently blameworthy to warrant a significantly greater penalty than what was given. I will say at paragraph 22, my lords, that there is some indication that the offense of luring could have been ordered to be consecutive. I accept and fall on my sword that that is not a submission I made to the sentencing judge at the time, but it is something that could be considered. And if I can just briefly look at tab 10, which is the local case.
Ms. Clarke, you're not urging that that should be a course that should be followed?
No. I'm simply saying that it's something that could have been considered, and I accept I did not raise it, but I just want to indicate, as I'm moving slightly to the offense of luring, that it is a separate offense that could have been ordered to be served consecutively if the court felt that 18 months and 12 months were the appropriate sentence. The one thing I will bring to the court's attention in the case of Martin, which is at tab 10, is that Mr. Martin was also convicted of one offense of unlawful carnal knowledge. He was initially sentenced to 2 years imprisonment. And the short comment that I wish to bring to the court's attention is actually at paragraph 12, which is on page 3. This is the judgment of then Justice Appeal, Mr. Ward. So paragraph 12, page 3, I think it's around line 10. It says, for the offense of unlawful carnal knowledge, imprisonment for 2 years concurrent, which could have been regarded as merely a slap on the wrist. So I would indicate that 2 years for the offenses for which we are dealing with was then considered to be a slap on the wrist. And the court just confirms at the end of paragraph 13, the offense of unlawful carnal knowledge is of a different genre and the sentence should properly be consecutive. But as I mentioned, I'm not trying to ask that now, simply indicating that something else that the court could have considered if it was found that 18 months and 12 months were the appropriate individual sentences. To consider the totality and the global offending, she could have then made those consecutive. So in other words, if I can move on to the second ground, which is about the offense of luring, it's agreed by my learned friend and myself, there is no local court of appeal authority set for guidelines for the sentence of the offense of luring. We've had 3 other indictments for the offense of luring in the Supreme Court. However, in each of those cases, the offense of luring was left on the file, so there has been no separate penalty imposed. I have tried to assist the court by providing at tab 11 the Sentencing Council documentation out of the UK. At tab 11, the first we put in was sexual assault of a child under 13, which is another offense that seems to be more of a, what we would call a exploitation. It doesn't necessarily require penetration in that offense. If the court may have found that of use. My other friend I know says that he takes issue with me referring to section 5, which is the more serious offense. So I have listed section 7's offense as well. But the third page of that tab, the court should see meeting a child following sexual grooming.
Sorry, don't have that yet. Whereabouts?
So it's tab 11.
I've got tab 11.
It should be the third page in. You should see, it should say Sentencing Council, meeting a child following sexual grooming.
Well, what that shows is that you probably accept that this would be a category 3 in the UK classification of luring.
Sexual grooming offense?
Yeah.
So, my lord, no, I actually don't agree with that. So I was going to take us through. So if you look at the categories that are listed in step 1, category 1 is a raised harm and raised culpability. Category 2 is raised harm or raised culpability. And category 3 is grooming without raised harm or culpability factors present.
Yeah.
At that page, it lists out what factors indicating raised harm are. And if we turn over the page, one of the factors is the child is particularly vulnerable due to personal circumstances. I don't know how much of the appeal record has been read by the court, but one of the things that the defendant admits is that this young lady had gone missing at one point. So she was a non-troubled young lady, if I can call it that. So we would have said that she was in fact vulnerable due to her personal circumstances. So that we say is one factor that's present. And then in the factors indicating raised culpability, there is communication indicating penetrative sexual activity is intended. And that is present in this case. So we would say we're probably a category 2, if not a category 1 starting point. Keeping with the guidelines, so having said my submission is that this would be at least a category 2 or maybe a low category 1. We look over at the statutory aggravating factors, which we admit are not in this case. We don't have any previous convictions. It wasn't committed whilst on bail. None of the aggravating factors listed in this guideline are present. There are 2 mitigating factors listed. The no previous convictions and the previous good character and or exemplary conduct are present. And then, of course, we then go to the reduction for a guilty plea and totality. So we would submit that in lowering the appropriate offense would be a starting point of 2 years custody, with the category range of 1 to 4. There is no aggravating features and then there is a mitigating. But as I mentioned, we put this in simply to try to indicate and assist the court with setting some sort of guidance for us locally on trying to deal with those offenses.
Ms. Clarke, could you help me with one thing?
Yes, my lady.
Because I have read a bit of, well, most of the record. The fact that the victim is vulnerable or may have a troubled background, why is that relevant unless the defendant knows that?
My lady, it is not something that we would have normally listed as an, and I'm just making sure I've used the term right, as a factor indicating raised harm. Bermuda doesn't tend to follow these UK sentencing guidelines as strictly, obviously, as you have to in the UK. I raise it only at the question of my Lord President as to which category it would fall in. That isn't something that we submitted was an aggravating feature at first instance.
Yeah.
Not one that has normally been accepted in these courts as an aggravating circumstance, unless it was more of a mental health type of vulnerability.
Which was obvious to the
accused at the time.
The accused at the time, yeah. So you're not relying on the fact that she may have been more troubled?
No, I'm simply indicating that in trying to apply the UK guideline for the offensive lowering, that is something that would have been taken into consideration.
Yeah, okay, thank you.
So, my Lord, unfortunately, that took me longer than I would have usually done in my submissions. I'm usually quite concise, but those are my submissions in respect of these 2 grounds. We simply indicate that we think the Glenn sentencing judge started too low in respect of UCK, and that the authorities that we've got to put before the court were not of any use to her one way or the other. Mine by saying they were too serious, my Leonard friends by not being serious enough. That it's inappropriate to say what would have happened had he been charged with the less offense and had the victim been 8 months older, and that there was no guidance at all in respect to the offensive lowering. So,
Ms. Clarke, just going back to what you have to say about the luring sentence. I mean, the judge obviously took a very serious view of the luring.
He did, my Lord, yes.
And said so, but if she fell into error, perhaps it was by applying the appropriate starting point for luring when compared with the appropriate starting point for the more serious charge of unlawful carnal knowledge.
That could be the only error I could point out, my lord, with respect. I can't say that she specifically started too low because we don't have a guidance case, but I would say yes, the fact that she's started too low compared to where she started for the defense.
Yeah, but she made some comments in relation to the luring, which indicated how seriously she took it.
Yes, as I mentioned at one point, I cannot take issue with the comments or even the procedure. It was just the starting point was too low.
No, I've found the passage I was looking at, which she says, luring in these circumstances is as egregious as the act of sexual conduct with a girl as young as 13. After all, without the luring, the sexual conduct would hardly have happened.
That's correct, my lord. So unless I can give any further submissions, my lord, my lady, those are my submissions.
Not from me, no, thank you. Well, thank you, Ms. Clarke.
Thank you.
Mr. Richardson?
Can I be heard?
You can.
Thank you. Good morning, my lord, my lady. I'll just dive right in with beginning with my submissions at paragraph 1. Ms. Clarke is correct. I don't think there's any disagreement between us as to the principles this court has to apply in determining whether or not the sentence imposed by the judge was manifestly inadequate. So I'm not going to belabor that point. I pick it up at paragraph 2. We say with respect to paragraphs 4, 5, and 6 of the Crown submissions that the factual matrix was a little more detailed, but I can tell from the comments of my lady Gloucester and one or two of the other my lords that you have actually taken a look at the facts in a more wider context. Yeah. So I won't bother you with that. With respect to paragraph 4 of my submissions, my lords, we say with respect to paragraph 10 of the Crown submissions, we say that the sentence passed by the learned judge was in fact consistent with previous sentences before the Supreme Court and the Court of Appeal in Bermuda in similar factual situations. The cases that the Crown have relied on as providing guidance for the proper sentence of unlawful carnal knowledge are, as we've obviously seen, based upon facts which are totally different to the case at bar, far more serious.
There's really nothing between you on all this in terms of structure. There's one set of cases that is manifestly more serious, and there's another set of cases that is plainly less serious. And everybody's agreed that this case has got to be pitched somewhere between them. It has been, but the question is whether it was at the right part of the spectrum.
Yes, my lord. That being said, my lord, I'll try and grasp the nettle that my lord has put out there. And I will say that perhaps the discussion has taken a divergence between myself and the Crown, because the Crown seemed to believe that the authorities that I've relied on with respect to section 180, which I think is the less serious offense, 14 to 16 years old. That's the cases of O'Connor, Smith. The Crown seemed to believe that those cases are less serious, but I would like to remind the court that the difference between the maximum tariff for the section 180 offense and the section 181 offense is 5 years. There's not a great gulf, and the conduct which is encapsulated in both of those offenses is quite similar, except for the age distinction, and that one deals with below 14 and the other deals with 14 to 16. I know that my learned friend has included in the bundle sections of the criminal code,
yes,
which clearly set out the maximum sentences. And I think that's to be found at tab 2. Tab 2, we see section 180 is the offense with which we are concerned, I believe. And the maximum sentence upon indictment is 15 years. Sorry, 25 years, subparagraph 1. And with respect to section 181, the maximum sentence on indictment is 20 years. So there's a difference of 5 years in the maximums for both offenses. And I think it's trite that when a judge is deciding where a starting point should be and where a case should fall along the spectrum. What the maximum sentence is a very relevant consideration. So the question, I guess, and my Lord President has, I guess, thrown it out there, is does the 5-year difference make a difference? The 5-year distinction make a difference? And I'd ask their lordships to look at one of their own previous decisions very quickly. It's the case of Brangman at my friend's tab 3, where that actual consideration by parity of reasoning did come up. And the court, I think, made a very relevant observation that can be applied here. It's at paragraph 15 of the judgment of Brangman, where the judgment reads, the judge sentenced the applicant in circumstances where he described the maximum penalty for all 3 offenses as 25 years imprisonment. In that he was in error, having been misinformed as to the position by both counsel. At the time that these offenses were committed, the maximum sentence prescribed for each of them was 20 years. The relevant maxima were raised by amendments on the 18th of July, 2006. The cases to which the judge was referred were cases which arose after the amendment. We do not regard this misunderstanding as significant for the present purpose, given the wide gap between the sentences in fact imposed and the maximum, whether the latter be 25 years or 20 years. Nor do we regard the cases decided when the maximum was 20 years as irrelevant for that reason. My lords, I read that as saying that if we had a case where the sentences that we were considering were very close to the maximums that could be imposed for each offense, then the difference in 5 years would in fact be palpable. But for these purposes, when we're dealing with sentences, which even if the Crown were to ask or were to receive the sentence that they have asked for, are well away from the maximum, well at the lower end of the scale that is available, the 5-year difference, I agree with the court in paragraphs 15 and 16 for the purposes of this analysis, should not trouble you.
So what you're saying essentially, Mr. Richardson, is that Ms. Clarke's argument that these are an altogether different category of offence should not be accepted, and Sir Christopher's comments in Brangman support that position.
I'm not saying that to be very specific, to say that it is not a different category of offense, I wouldn't say that. What I would say, I would preface that for sentencing purposes, the fact that there is technically a different category of offense does not make the authorities which I relied upon and placed before the trial judge unhelpful. In fact, it makes them very helpful in light of the fact that there was no other guidance available to the judge on this occasion. And the factual simulation situations were very, very close. My learned friend seems to only take issue with the fact that the offense under section 180 is more serious and carries a higher maximum sentence, but it's a 5-year difference, and that's all. And I guess I'll move right quickly to the other point my learned friend seems to make, which is at paragraph my learned friend begins to make the point at paragraph 19 of her submissions when she cites the cases of Gribby and Attorney General's reference number 142 of 215, the case of Brown. And I'd just like to point out that the sentences imposed in both of those cases, I think they were 3 years and 4 years respectively. This is on a tariff of life imprisonment. The offense that they were sentencing.
When you say both of those cases, I've got Brown. What was the other one?
Gribby, and then there's Attorney General.
Right.
Yes, my lord. Those were considering tariffs with the, and I think I've included that tab. It's at tab. You'll find it at tab 15. An extract of the offense that was being considered in both Gribby and Attorney General's reference, Brown, rape of a child under 13. And you'll see that the sentence imposed is imprisonment for life, which is a far cry from the 25-year maximum that we have to consider, or that the judge in this case had to consider. And for that reason, I'd say that the authorities of Gribby and Attorney General's reference aren't really helpful to this court in setting the proper range. And my further submission on this point would be that the offense in the United Kingdom, which would be more akin to the conduct that this court is being asked to look at, would be, and it's at the next page, Section 9 of the Sexual Offences Act 2003, which covers an age range of 13 to 17, covers the conduct in this case, penetration of that vagina or anus or penetration by mouth, and the maximum is 14 years in custody. That would seem to be more appropriate and more comparable. And I have included, I believe, 2 cases where offenders were sentenced for that offense. I believe the first is at tab 12, R versus Richardson, no relation.
Just going back, you said both Gribby and Brown were 3 years.
I believe one was 3, one was 4. Don't quote me on that, my Lord Justice.
Well, I'm just looking at Gribby, which I think was 2 years.
I stand to be corrected. That would actually lend more support to my argument, because again, we're dealing with a tariff.
Am I right on that? Just look at paragraph 3.
Yes, let me look. I believe he ended up with 3 years, paragraph 34. 3 years detention. And again, this was on a tariff of life imprisonment. That's at paragraph 34.
Right, thank you. The 2 years was the original.
The initial sentence, yes, my Lord, which was found to be, it was suspended actually, but it was found to be manifestly inadequate. Yeah. I take my Lords now to the case of Richardson, which is at tab 12. It's a section 9 offense. They're very brief extracts, so I'll just, the victim and V lived in the same village, shared a common group of friends. R was age 20 and V age 15 when they entered into a consensual relationship. They had sexual intercourse on 8 occasions. The relationship was discovered when V's parents installed software in her mobile telephone, enabling them to track and intercept messages. And if you've read the records, my Lord, you will know that although sophisticated tracking software was not used, essentially these offenses came to light because the complainant's mother indeed did see a series of text messages in her phone. She took
the victim's cell phone as a punishment, and that led to the discovery of these letters.
Yes, my Lord. A series of text messages was discovered referring to the 8 instances. We don't have 8 instances in this case. V ended the relationship after she became concerned that R was only interested in sex. R pleaded with V not to end the relationship. At the sentencing hearing, it was common ground that applying the Sentencing Council's definitive guidelines on sexual offenses, that the offending fell within category 1 by virtue of the existence of penetration. The recorder concluded that for the purposes of harm, the offending fell between category A and B. V was not vulnerable for the purposes of the guideline, but the fact that R knew that she had previously made an allegation of sexual abuse against a family member was an aggravating feature. That's not present in this case, in addition to the pressure placed on V to continue the relationship. No further aggravating features to the guideline applied. Eventually, you'll notice that the sentence which was handed down was 12 months imprisonment, and this was after trial. So I'd say that that particular authority, and my Lords may agree or disagree with me, is more helpful in determining what guidance this court, and let me make this clear. I disagree with my learned friend that the sentence in this case is manifestly inadequate. What I do agree with her on is that we do not have specific guidance with respect to section 180. So it might be helpful for the court to dispel or deal with this suggestion that the cases under section 181 are not helpful. And if they aren't helpful, it might be nice for the court to say why they're not helpful. And if they are helpful to a certain extent, the court should, I guess, set a limit. And it's probably for this reason, I agree with my learned friend on that. One of the most prominent questions asked by defendants when you are advising them on matters like this is, Mr. Richardson, what am I looking at? How much time am I likely to get? And it would be really helpful if we could tell defendants in some definitive way, and this probably needs to be done across the entire spectrum of criminal law in Bermuda, this is what you can expect on these facts, because we probably have a lot less trials and a lot less litigation, but that's an aside.
I hope you don't give them the advice that was reflected in your rejected submissions to the judge.
No, my lord, I hadn't. My lords, if I could then go over to paragraph, I think it's tab 13, in which I include the case of the Attorney General's reference number 67 of 2008, Sharon Edwards. Again, that is a section 9 sexual offenses act offense. And the eventual sentence was 12 months imprisonment. Again, on a tariff of 14, on facts that are very similar. Of course, in this case, the complainant was actually a young boy and the defendant was an older woman, but she was 40 years old, he was 14, and the court made the point that there should be no difference applied in sentence because of the gender difference. And I don't think anyone, even my learned friend, is going to dispute that. So I asked the court to accept that case as providing valuable guidance on the level of sentence that should be imposed in cases of this nature in Bermuda. And the final authority I refer you to, my lords, is at tab 14. It is the Attorney General's reference R versus R. Again, an age range of 13 to 17, a sexual offenses in section 9 case. And again, it is put before you, and I'm sure you've read it or will read it, as an example of a case with similar facts with respect to conduct and the disposition of the offender versus the complainant, and should give you greater guidance than the cases my learned friend has given you with respect to what would be the appropriate starting point in a case like this. Now, my learned friend does make a submission, and I noted it in her submission, that historically, paragraph 17, this offense, the offense of 181, under 181 has historically received lighter sentences. I'm at a pains to see how my learned friend can make that submission when we don't have any record before this court of the sentences that have been meted out for section 180. There are literally no authorities in this jurisdiction with respect to that. And I would say that in this case, when the learned judge placed reliance on the section 181 cases that I did place before her, that was an entirely appropriate approach to take, and that the manner of reasoning that was employed did not fall afoul of any principle. There are two sections that I would like to take.
Can you just, Mr. Richardson, before you go on, could you just take us to the part of the sentencing remarks where the judge deals with the section 181 cases?
Yes, I think it's on page 22 of the sentencing transcript. I've made a mark that that's where the cases appear to be discussed. In fact, it begins on page 21.
Right.
Line 18.
So although the judge took the view that there wasn't as much detail as she felt she needed for the cases to be helpful,
yes,
she certainly looked at those cases on the basis that they could be helpful.
Yes, yes, and my submission would be that in the landscape that the judge found herself in, that was a totally appropriate process to follow, and that the sentence she arrived at cannot be considered to be manifestly inadequate. On page 22, my lady went through the case of Malik Zul.
Give me a moment, Mr. Richardson, to catch up with. Yes, thank you.
At page 22, at line 6, you'll see the court make reference to Malik Zul. And in each case, the court is careful to set out the age ranges. At line 11, the court cites the case of Aaron O'Connor. At line 20, the court make reference to the case of Raymond Smith. And the court at page 23 says this. So there were insufficient facts before the court in each of these cases. The court did not know whether—
Sorry to stop.
Oh, sorry,
Mr. Richardson.
Am I speeding ahead?
Where is Raymond Smith in that? That's not Sean Gordon Smith, is it?
That's not Sean Gordon Smith. In fact, Sean Gordon Smith was not cited to the sentencing judge.
And is Raymond Smith in the bundle that we have?
Raymond Smith is not in the bundle before you.
Right. Thank you.
At page 23, we see the court at line 11 says it is important that a sentencing judge sets out those matters so that anyone referring to the cases can see the reasoning behind the sentence that is ultimately given. Nonetheless, this court, doing the best that it can, must apply the appropriate sentencing principles. The court bears in mind that it has responsibility to deter you from committing a crime or crimes such as these, again, but it also has a responsibility towards general deterrence. That is, deterring other men from engaging in sexual activity with young girls. The court determines that in your case, clearly the judge is saying on the facts of this case, the starting point is one of 2 years imprisonment in a range of possible sentences of 1 to 4 years imprisonment for unlawful carnal knowledge. And my submission would be that in saying, making that pronouncement, that the starting point in this case is 1 of 2 years on these facts, and the range of possible sentences will be 1 to 4 years, is actually smack dab in line with the Sentencing Council's guidelines, as President Maurice K indicated, with what an offender would receive for this type of conduct. And without even having made reference to those guidelines, I think the judge got it absolutely right, and she can't be faulted in principle. The judge continued, the child with whom you had sex was not unaffected by your conduct. She suffered a loss of relationship with her mother for a period of time, and she suffered from low self-esteem, all as a result of your conduct. Nonetheless, on the scale of harm, the harm in this case falls on the low end of the scale. As to your culpability, that also falls on the lower end of the scale when compared with more egregious conduct by sexual predators, such as those referring to in the cases against young girls that the prosecutor relied on. So clearly the judge took into account the authorities that were proffered by Ms. Clarke and rightfully took the view that those were cases which related to far more predatory, egregious, and reprehensible conduct than the facts before her. And she certainly would not have considered those cases as being helpful in determining a starting point in a case of this nature. Judge continued, you are entitled to a reduction in your sentence for your early guilty plea. Taken together with your lack of previous convictions, the court will apply a reduction of 30%. Your sentence, therefore, on count 1, unlawful carnal knowledge, is 18 months immediate imprisonment. And our submission to you, my lords, is that that process and the sentence that the judge has arrived at is not manifestly inadequate. No one is going to take the view that someone in the public eye would think that something has gone wrong, because those sentences are in fact on par with what one would usually expect to receive for these types of offenses. Now, just with this caveat, if my lords were of the view that perhaps guidelines should be given which indicate a slightly higher sentencing range or approach, I would ask that my lords, if you feel that, give that guidance, but do not disturb this particular appellant sentence on the facts of this case if you wish to give guidance which is applicable to future cases. He's some way into his prison sentence now, and there might be an element of unfairness there, but I'm hoping to persuade you first and foremost that his sentence is not manifestly inadequate and it should not be disturbed. With respect to the luring, my lords, I do agree with my learned friends. We don't have any guidance on the luring. And that, again, as you can tell from my earlier comments, is something that we would welcome. Because if we're going to see more offenses of this nature, it would be nice to be able to advise defendants from the outset as to what they could expect on a guilty plea versus trial, et cetera, et cetera. What I will say is this, though. Even in
Sorry,
my
Mr.
friends,
Mr. Richardson?
yes.
But surely you would say that if the judge is right on her sentence for unlawful carnal knowledge, what she says in relation to luring is perhaps appropriate.
I'm sorry, Lord, which part of what she says in relation to the luring? The sentence or a particular remark?
No, I'm thinking of the sentence rather than any particular remark. I've referred to how she viewed the luring and the seriousness of it. But if she was right on the sentence for the unlawful carnal knowledge, presumably she was right on her sentence for the luring in terms of the level of disparity between
the two. And the reason why I think 12 months would have been appropriate on the luring, even though she gave 18 months on the unlawful carnal knowledge, yet the luring has a lower maximum tariff. It's only 10 years.
Yes.
So that would, in my submission, justify that incremental shift downwards. And the judge would be well within principle to have passed the sentence of 12 months in light of the fact that the
luring actually leads to the offence, as it did here. It's all part of the same offending, really, isn't it?
Yes, and that's another reason why it should not have been consecutive. And in actual fact,
I have no difficulty in accepting that. So
I see. Well, that would be the only other issue that I would have troubled my lords with the judge deals with on page 25, in which she takes into account the totality principle, yes, and the possibility that it could be consecutive, and says that I'm going to impose concurrent sentences. And I think that the judge was rightfully entitled to do that. Yeah. My lords, I think that we've gotten right to the nub of the matter, and unless I can assist you any further, those are my submissions.
The authorities relied upon by Ms. Clarke included those two relatively recent English cases of Gribby and the Attorney General's reference in Brown. I don't think those were before the judge on sentence, were they?
They were not.
And you sort of distinguish them by saying, well, they're different offences, different maximums, and so on. Is there anything else you want to say about the approach in those cases?
I do accept that the judge's remarks with respect to how you treat the age differences, and I don't think that's a submission that was advanced, that, oh, she was just shy of it. So I do accept that particular principle. That is applicable across the region.
The judge accepted it. So she didn't have the cases. She didn't have the cases cited to her, but she said more or less the same thing.
Yes, and I can't disagree with that, my lord.
Yeah. Okay. Nothing else?
No, my lord. Those would be my submissions.
My colleagues have any other questions for Mr. Richardson?
No, thank you, Mr. Richardson.
Okay.
No, thank you very much, Mr. Richardson. Ms. Clarke, anything to add?
The only comment I would say, my lords and my lady, is that Gribby was not relied upon by me to say the appropriate sentencing range, but to talk about the procedure and the fact that you cannot look at the lesser offense by saying a victim is only a few months short of having the defendant fall into that offense. And so I would submit that my learned friend, referring to his 3 UK cases of Richardson, Sharon Edwards, and R&R, is doing the exact same thing, looking at a lesser category of an offense, because the facts may be slightly more similar to what the case at bar is. So that really is the Crown's crux of complaint, is that we cannot look to different categories of offenses for guidance for this offense. And that's my only comment in response.
Thank you very much indeed.
Even though,
I'm sorry?
I was going to say, even though Sir Christopher Clarke in Brangman suggested that one might get some benefit.
So no, and I should have, thank you, Justice Bell, for reminding me. I actually argued Brangman, and that is not what that paragraph was about. There was an issue with the sentencing judge. He was advised by counsel at first instance of the wrong maximum penalty.
Yes.
And,
Yes.
So that was the issue that was being discussed in those paragraphs, because I had to concede that the judge may have been too high because he was looking at a higher penalty than what was available. And the court said it wasn't much of a difference, because similarly in the case of Roger.
So I mean, cutting across, Ms. Clarke, what Sir Christopher was referring to was a different maximum, not a different offence.
That's correct. So
yes.
In Brangman, the sentencing judge was given too high a maximum, but also the cases he referred to, it was a similar problem in Rogers, that sentencing judge had too high a maximum. So he was saying it didn't make a difference because even though the maximum was only 20, the cases that the sentencing judge was referring to was saying it was only 20 anyway, even though that case had 25.
Yeah. Thank you.
That's a particular comment about it doesn't matter that the maximums are different. Judge wasn't anywhere near it in that sentence. I hope that's of assistance.
Yes.
Yep.
Well, thank you very much. Indeed, thank you both very much for your submissions. We shall not be giving judgment today, but we hope to hand judgment down during this session, in other words, in the next fortnight or so. But thank you very much. And
all right, thank you all. That concludes these proceedings. If you can depart from the virtual room.
Thank you. I'm joining the breakout room.
I'll do the same.
Likewise.